This is an interview with Professor Larry Marshall from the Northwestern University School of Law, who is the legal director of the Center on Wrongful Convictions at the Northwestern University School of Law. Larry, there are a number of cases in our data set which result in sentence of death and the defendant being executed. And of course, the Center on Wrongful Convictions at Northwestern has been very important in the developments regarding the death penalty in Illinois. Why don't you start by telling us a little bit about what's been happening in Illinois and the extraordinary developments here?
Well, as you know, in the late 1970s, the death penalty took a new turn across the country. The U.S. Supreme Court had struck down the death penalty in Furman versus Georgia, holding that it was too arbitrary, that the issues of race were too predominant, that there was even a risk of innocent people being executed. But within 4 or 5 years, 38 states had brought back the death penalty, and the Supreme Court had approved the new versions that these states had implemented and had decided to give the states an opportunity for another shot at it. States had claimed that they had improved their statutes, that they had reduced all of these problems of arbitrariness and the like. And from around 1978 here in Illinois until 1990, we had a pretty robust death penalty with sentences being imposed and with support for the death penalty being very, very high.
And this was typical of what was going on in other states which had reenacted after Furman, the so-called Gregg states, correct?
That's exactly right. The Illinois was very typical of most states, although it was somewhat atypical in that a lot of the northern states did not have a death penalty. So, for example, Michigan was without a death penalty, Iowa was without a death penalty, Minnesota, Wisconsin.
Right.
So in some ways, among the northern states,
Yes.
Illinois was sort of an island with the death
Right.
penalty, but nonetheless, Illinois is obviously a state that has roots connected to Indiana and some other states as well, which did have a death penalty. Support was very high indeed, but beginning in around 1990 or so, a new issue began to hit, and that was the issue of innocence. Starting in the very late 80s, but finally through the decade of the 90s, we began to see a really unprecedented series of cases in which innocent people had not only been convicted, but had been sentenced to death.
Not just, when you say support for the death penalty had been high, you mean public opinion polls showed something like 80%?
Sometimes you could ask the question a bit differently and the support would be much lower. And that remains the case today throughout the country. If you ask someone, do you support the death penalty when the option is life without possibility of parole, usually the numbers end up being very close to 50-50 nationally and in Illinois. But if you ask the simple question, do you support the idea of a death penalty, 70 to 80% of the folks in Illinois were saying yes back then through the 1980s into the early 1990s. My own involvement with the issue began in 1990 when I was asked to represent a man named Rolando Cruz who had been convicted twice and sentenced to death for a terrible murder of a young girl in Naperville, Illinois.
Now, this was pretty unusual. You were a criminal law professor and you were teaching in a law school. You weren't practicing criminal defense. How did this happen?
I was doing some appellate work generally, and the lawyers for Cruz, who had, again, now been convicted for a second time for the same crime, believed that they needed someone unusual to argue his case, that if it was a usual suspect, the Illinois Supreme Court might not pay as much attention. Cruz was asking to be the first person in Illinois to ever receive a third trial after having been twice sentenced to death, and we knew we had a tremendous uphill battle. And as I began to study that case, my own transformation is very similar to, I think, what's happened to a lot of people here in Illinois and around the country, and that is that I used to believe that although there were many problems with the death penalty associated with issues of race, issues of arbitrariness, issues of bad lawyering, I knew all of that.
Poverty.
Poverty, for sure, which of course, ties directly into bad lawyering. I used to believe that notwithstanding those problems, there was one thing you could take to the bank, and that is that if someone was on death row, they absolutely did the crime. So when I was first asked to look at the Cruz case, and I was told by his lawyers at that time, oh, this is a completely innocent man, I was very skeptical. But yet as I studied the case, it became as clear as day to me that Cruz was absolutely innocent, that another man was the guilty party. He had in fact confessed to having committed the crime alone. But even then, as I threw myself into the Cruz case in a way that I've never thrown myself into a case before or since, I believe that that was the rare aberration, that this couldn't be something that was typical. But after the Cruz case began to develop more public attention, I began to get more letters from other inmates. And as I looked at those letters, most of them seemed to have very little merit, but some of them, particularly some of them on death row, struck the same chord as the Cruz case had struck, and seemed to me to be cases quite clearly of grave error and indeed of wrongful convictions.
So when you got a letter from an inmate in prison, I mean, anyone who's done criminal defense work gets a lot of these letters saying, you know, I'm innocent, come see me and get me out. What do you look for as indications of, you know, that this person maybe really is innocent? And how do you start your initial investigation?
Well, as time passed on and I became a bit more sophisticated in understanding the causes of wrongful convictions, one could begin to develop a sense for the kinds of cases that are particularly suspect. So, for example, cases that are built in large part on jailhouse informants are classically very problematic cases, because that suggests that the evidence wasn't there sufficiently when the person was even charged, yet it was being built once the person was thrown into jail awaiting trial based on very unreliable witnesses. Cases of confessions that had never been recorded, had never been documented very closely, and did not have within them facts that proved the individual's guilt. In other words, self-corroborating details.
Cases in which there were no physical evidence.
Cases in which there was no physical evidence, to be sure. And several other categories began to emerge as cases that justified closer looks. And back in the 1994, 5, 6, we weren't getting that many letters at the law school, at least I wasn't, and therefore was able to look at each one quite carefully. Now, based on those letters, I ended up representing several other clients, representing a group called the Ford Heights Four, in conjunction with the journalism school here and a bunch of other lawyers around town who represented the other defendants in that case, represented a man by the name of Gary Gauger, and innocent men who were all ultimately exonerated, and indeed by the end of the 1990s had been involved directly in 9 of 13 cases throughout that decade in which innocent men had been exonerated for crimes that at one time they'd been sentenced to death for.
Well, this was an extraordinary development. Now, Illinois at that time had a death row population of somewhere around 160, 165. So for 13 men to come off of Illinois' death row, you had both a domino effect, but also wasn't that just an extraordinarily high number?
It was indeed a very high number. The 13 out of 170 or around 170 is extremely high. Another way of looking at it, which is even more startling, is to recognize that you really can't look at just the 170 and say they're all guilty, because we don't know whether they're guilty or not. Let's look instead at the cases that have come to closure, either through exoneration or through execution. By the year 2000, Illinois had executed 12 people. At the same time, it had exonerated 13. So of the 25 cases that had come to closure, more than half of them, 13 out of 25, had come to closure through exoneration as opposed to execution. And that's not to say that even those who are executed are undeniably guilty either. Mm-hmm. The startling thing to me in working on these cases was the extent to which the showing of innocence depended on a series of miracles, a series of serendipitous events that we couldn't possibly rely on. Cases where journalism students were able to find the witness who would finally come forward and admit she had lied earlier. Cases where a tiny bit of DNA had been left in a test tube, everyone believing that the DNA had been destroyed a decade earlier. Other kinds of situations like this. And you realized that for every case in which those miracles were happening and innocence was being shown, there had to be so many others. Logic demanded the acknowledgement that there had to be so many others who were equally innocent, but whose miracles had not yet come.
So one of the things that you were seeing was a legal system which formally looked like it was very strong and ironclad in terms of giving rights to the defendant and rights to appeal certain factual allegations, really was seen to be quite flawed, and it turned out that often the people who were found to be innocent were found to be innocent not because of these pillars of legal principle, but a sort of accident. Give us an example of one of those.
Well, an example, I suppose, would be the Gary Gauger case. Gary Gauger had been convicted of killing his parents on a farmhouse where they all lived. And ultimately, what led to his exoneration was the serendipity of the fact that the FBI happened to have a wiretap going years and years later in the clubhouse of the outlaw motorcycle gang. The FBI wasn't interested in the Gauger case, didn't know anything about the Gaugers. They were looking into entirely separate criminal activity involving a war between the Hells Angels and the outlaws. And sure enough, happened to pick up on the wiretap two of these outlaws bragging about how they had killed Gary Gauger's parents, and that they knew they would never get caught because Gary Gauger was on death row for the crime that they committed. Each of these cases had those kinds of miracles. And what we began to understand is that although there were many appeals available, direct appeals, post-conviction appeals, habeas corpus, the one commonality to all of those appeals is that none of them is or was very concerned with the issue of innocence. You see, we have a lot of ways of appealing legal errors. Was there a mistake in introducing certain evidence? Was there misconduct? Was evidence turned over? And things like that. But as for the core question, which is, should this person have been convicted based on the jailhouse informant? Was the confession reliable? Was the eyewitness identification reliable? Those are things that the law treats as questions of fact, that it allows the jury to decide and basically gives virtually no review whatsoever. And
let's go back to the juries, because what we all think and hope is that the juries are going to act as correctives here. The juries are going to have common sense, and indeed we see in the historical period the juries play a very important role, although perhaps the judge and the prosecutor are able to say things and influence the jury in the historical period the way they can't now. But what about those juries? Were these juries just rolling over?
Well, not in all cases. And we're looking at a sampling of cases where convictions actually occurred. The jury system, to paraphrase the famous quote about democracy, is in fact the greatest, I should say, the worst system in all the world, except for all the others. And the reality is that jurors, I believe, go into that box usually trying to do their absolute best. But that doesn't mean they can divorce themselves from so many background biases and perspectives that thwart the search for truth. Part of that is, of course, racial stereotypes and unconscious views about race. Another large part of it is that jurors are not ready to be involved in these kinds of deliberations, often where the crime was so heinous. In other words,
it's so shocking for them.
When a jury sees the picture of a brutal crime, in most cases, that's the end of the story. Because what we need from a jury, what we need from a trier of fact, is a model of dispassionate deliberation. When you have a crime of that kind of intensity, when you have the family victims of the family members of the murder victim in court, so clearly rooting for a conviction, rooting for a death sentence, believing that's all that's going to bring them closure. In many cases, jurors will nonetheless, when the evidence isn't there, say, we're sorry, but we have to acquit. But in many other instances, and I've spoken to jurors who have told me this, they basically said, hey, look, we're going to convict. and let some other court figure it all out. Because we
Yeah.
know if we acquit, we're the last word.
Right.
But if we convict, and the person's really innocent, of course, that will come out on appeal. That will come out on habeas corpus
Right.
or wherever else it might come out. So the jury system, yes, I'm not suggesting any other system, but we do need to recognize that it too is fallible because it too is made up of human beings.
Well, let's also talk a bit about the role of the prosecutor and the role of the judge. And in the historical cases, we have several instances where prosecutors, most notably the prosecutor in the Leopold and Loeb case, Crow, who later becomes a quite well-known judge, was a very political person, and prosecutors were elected, judges were elected. We have some very interesting instances in the historical period of judges talking about the election process and how it was influenced. But recently in Illinois, we've had prosecutors who've run on the death penalty and who've said, you elect me state's attorney and I'll see that, we execute more people. And this isn't just true in Illinois, but in other parts of the country as well.
There's no question that politics and political pressure can play a role in prosecutors' decisions on whether to seek death. I tend to believe it's usually more of an unconscious than a clearly manipulative or conscious role where the prosecutor is saying, I need to seek death because the election's in 4 months. But I think at an unconscious level, it clearly has impacted on prosecutorial discretion. Here in Illinois, my own belief is in the past 4 or 5 years, that's flipped around dramatically to the point where the public is so concerned at this moment about accuracy and fairness in the death penalty that prosecutors are actually feeling the need to be very cautious and not get ahead of the public on that issue.
It's extraordinary what's happened in Illinois, where you do see this huge turnaround, not only in public opinion, which you can measure in the polls, but also in public attitudes and attitudes of prosecutors and defense attorneys, attitudes of judges. I mean, how did this come about?
Well, as I said, it began with a spate of cases, with a great deal of luck, where a bunch of cases in a domino effect began to fall within a short number of years, and the public began to say, this looks interesting. In 1998, convinced that these cases were not isolated occurrences, but were part and parcel of what the death penalty looked like, Northwestern decided to hold a conference which has been credited nationally with really having changed the tenor of the debate about the death penalty in this country.
I think that conference was very important.
And most certainly in Illinois. And it was
Yeah.
called the National Conference on Wrongful Convictions and the Death Penalty. And what it did was to bring together 30 or so men and women who had been sentenced to death, have them sit on one stage and have them tell their stories. And when folks saw those people sitting on that stage, an image was seared in their mind that this is another face of the death penalty that they had not been thinking about. That one was used to thinking about John Wayne Gacy or Jeffrey Dahmer or Ted Bundy, but no one had thought about this side of the death penalty debate. And we also brought together, of course, all the national leaders and activists and lawyers and giants, Tony Amsterdam, who had argued Furman versus Georgia in the U.S. Supreme Court. So many others came together. And a decision was made at that event that we needed to broaden the debate on the death penalty, that there were so many people who said that they supported the death penalty in theory, but who didn't know about the realities, about the practicalities of how it's administered. Thurgood Marshall in Furman versus Georgia, in ruling that the death penalty was cruel and unusual, was faced with a problem of the fact that, as we spoke about earlier, all the polls showed tremendous support for the death penalty. And he confronted that problem and he said, I don't care what the polls show, because the polls are not polling people who know about the realities of the death penalty. If you show me that people who really know about the issues of race and arbitrariness and class and bad lawyering and innocence then still support the death penalty, those polls would be significant. And I will tell you that over the past 14 years now that I've been working on the issue, having spoken to hundreds of thousands of people in audiences large and small, I've had hundreds, if not thousands, of people come up and tell me that over the past few years, even though they still believe in the death penalty in theory, they have come to reject it in practice because of their understanding of the unfairness and the inaccuracy associated with its application. During that same time, I have not yet met one person, not even one, who says that they used to doubt their support or used to reject the death penalty because they were concerned about unfairness and inaccuracy, but the past 10 years have persuaded them that it's applied so fairly and so accurately that now they've become heartfelt supporters.
Right.
And I submit that the measure of any public policy is that question. What happens when people become educated about the realities of the policy, when light is shown on the subject? And in this case, there's no question that when light is shown on the death penalty, people's support absolutely dwindles, and that's what's happened in Illinois. After the 1998 conference, a tremendous exoneration, the Anthony Porter came about, a case where he was within 2 days of execution. A bunch of lawyers, and Northwestern was included in this, the law school was included, were able to get a stay of execution, not because anyone doubted his guilt at that time, but because there were questions about his mental fitness to be executed, whether he understood what an execution was.
And an issue which, as I say, comes up in the historical cases. In the 1893 case of Prendergast, in which Clarence Darrow was the lawyer, it was again fitness to be executed. Now we all know, of course, that people are executed when they're not fit to be executed, and it's not raised very often, but it was extraordinary that it was raised in 1893, and again in the Anthony Porter case.
Well, Darrow was certainly a pioneer in understanding the impact of psychology on criminality and the point at which, unfortunately, some criminal acts end up being those of depraved and just really ill individuals. But in the Porter case, we were able to get a stay of execution within 48 hours of the execution. He had already been measured for his burial suit. The last meal had been ordered. And over the next few months, as the lawyers went about investigating his mental fitness and working with the experts, David Protest from our journalism school at Northwestern decided to have some students look into the case. And within really several weeks, they had gone out, done a crime scene investigation, had able to expose the fact that the key witness for the prosecution had lied and now admitted that he lied, were able to then investigate alternative suspects and find several witnesses who implicated another man as the killer, a man named Ulster Simon. And then finally, with the help of a private investigator, were able to secure a videotaped confession from Ulster Simon, which led to Porter's unquestionable release upon grounds of innocence.
And the extraordinary thing is when you read the direct appeal and the affirmance of the death sentence in the Illinois Supreme Court case of Anthony Porter, it is written with such certainty.
Well, if you look at the Porter case and think about what it says about the system's ability to work, you realize that a trial judge had signed off on it. 12 jurors had convicted him beyond any reasonable doubt, sentenced him to death beyond any reasonable doubt. 7 Illinois Supreme Court justices had found no problem with the question of his innocence or guilt. 9 justices in the U.S. Supreme Court had seen no problems in the case. It had then gone back again to the trial court in Illinois, back again to the 7 justices, then through the federal courts, where first a district court, then 3 judges on the Court of Appeals, then 11 judges on the Court of Appeals, and then once again the 9 justices on the U.S. Supreme Court had all looked at it, and no one had seen any problem. And I'm not faulting any of them, because based on the evidence that had been produced, there was no reason to doubt. There was no reason to be able to say this was a wrongful conviction. But that, of course, ended up being the problem. When people saw how that had happened, how close we had come, and how much of a miracle had to occur in order for Porter to be freed and for the true killer to be convicted.
Yes.
Because let's not forget, every time that we have an innocent man behind bars for a crime he did not commit, it means the guilty man is not behind bars for the crime that he or she did, or he did commit in this case. So
so it was another kind of needle in the haystack. Didn't the investigators find a record regarding IQ in a school report or something like that? Remind me of how they went about this factual investigation, what they found.
Well, the investigation into the IQ was something the lawyers have been doing. The investigation into the actual crime had to do at first with the students going out to the crime scene, something that Porter's lawyer had never done, and standing in the exact spot that the eyewitness claimed to have stood, and looking exactly where the murder took place, and realizing that there was a wrought iron fence that completely blocked any view from where the eyewitness was to the place where the murder occurred. And first they assumed, well, this wrought iron fence must have been put in the past 16 years, because this was 16 years after the murder took place that they were doing their investigation. But they shortly confirmed, no, that wrought iron fence had been there as long as anyone could remember, for decades and decades. And they then went and confronted the eyewitness and said, we got a problem here, because we went to the crime scene and you couldn't have seen what you claimed to have seen from where you claimed to have seen it. And the eyewitness basically said, look, I can't do this anymore. I didn't see anything. The police told me they knew Porter did it. The police told me that if I didn't go along and help do a public duty and put this guilty man away, that they were going to think of me as a suspect, and I had my own troubles with the police. So I basically played along thinking I was doing a public service. And that's how the case began to break apart.
Right.
But as I like to say, imagine that in those intervening 16 years, the wrought iron fence had been removed.
Yes.
So when the students went out there and stood where the eyewitness stood, they looked up and they saw, oh, there's a great view. They would have had no reason to doubt the eyewitness. The eyewitness never would have been defeated. They never would have gone or impeached. They never would have gone and done the alternative investigation. Anthony Porter almost undoubtedly would have been killed, because I don't believe that the mental health issue was ever going to hold up ultimately after trial. So when that case broke, the year was
huge.
It was huge. The year was 2000 at that time.
And we have to say also the role of the Tribune was very important in these investigations.
Exactly. Exactly. Once the I should say the Porter case originally broke in 1999, based on the conference that had been held, and then based a few months later on the Porter exoneration, a series of journalists at the Chicago Tribune decided that a really thorough investigation was appropriate here, that this seemed to be more than some isolated cases, which was, of course, the point of our conference, driven home so strongly by the Porter case. Now, I should say, because I think it's very important, that for so many decades, the newspapers in this town and nationally had really been part of the problem. There had been a great deal of capture of the newspapers by the prosecutors who were feeding them stories, and who were the repeat players with the journalists covering the.
And we must also say that murder is front page news in 2004 and 2000 and in 1900 and 1904, right on through. Murder sells newspapers. It always has. It always will.
Absolutely, and it was very rare for newspapers, and certainly the Chicago Tribune, the leading Chicago newspaper with very strong conservative credentials through the years, was hardly a pioneering force until quite recently on the subject of writing wrongful convictions. And the first person really to break that mold was Eric Zorn, a columnist for the Tribune, who became very involved, immersed, some might even say obsessed with the Cruz case, began writing about it in 1994, and ended up writing over 100 columns on the Cruz case, dissecting it piece by piece, tiny bit by bit, and totally proving to any objective observer that this was a great miscarriage of justice. By 1999, now a new team, Steve Mills and Ken Armstrong from the Tribune initially decided that they were going to do a thorough investigative series. And right around the time that a new governor was taking office, George Ryan, in the beginning of 2000, this article appeared.
An important 5-piece series in the Tribune appeared on capital cases and wrongful convictions.
Right. George Ryan had taken office in 2000. George Ryan had witnessed the exoneration of Porter while he was in office in the first couple of months.
Right.
And then shortly thereafter, George Ryan had been put in a position where he was faced with having to decide whether to go forward with an execution in March of '99, which he allowed to go forward, and that being the case of Cocorales.
Edgar was governor 1 term, 2 terms? 1 term.
Edgar was governor for 2 terms, wasn't he?
2 terms. Total of 6 executions during his
I
governor.
don't know.
Anyway, so 1999,
It
Governor
would have been
George.
more than that, because
Is
I
it
think
more
all the
in the second term?
Well,
Yeah.
I think all the executions. I don't think Thompson signed any.
So all
mean,
12
I think all of them may have been
were under
Edgar,
gag. Is that
'cause
correct?
Gacy was in 92,
Yeah.
3, something like that.
All right.
So yeah, but I don't.
That
remember
could
for
be.
sure.
That could.
I'm pretty sure.
Well,
I'm pretty sure it was all
all
Edgar.
right, but let's just say, so in 1999, Governor George Ryan is elected. He succeeds Governor Jim Edgar, who had ordered a number of executions in Illinois. Illinois wasn't up there with Texas in terms of the number of executions, but Illinois was executing people. Anyway, so George Ryan is elected, a Republican, a proponent of the death penalty, and
George Ryan's elected, a man who throughout his legislative career had been a strong supporter of the death penalty, a man who talks about how he would elbow others out of the way to get to the microphone to be the first to support expanding the death penalty. A man
voted for the death penalty on numerous occasions.
voted for reinstatement, voted for expansion, but had, as so many other people, really voted that way quite reflexively without necessarily thinking a whole lot about it. Well, what happens when this spate of exonerations and then the Chicago Tribune series exposing all of these just incredible facts about the Illinois death penalty,
And especially Anthony Porter.
and the Porter case, and the fact that the Tribune exposes that 33 of the folks on death row had been represented by attorneys who were disbarred either before or after. That gives you a glimpse of the caliber of lawyering people were getting, the extent to which so many of them, African Americans, were convicted and sentenced by all white juries, the extent to which so many of them had involved not withholding of exculpatory evidence and other forms of what we call prosecutorial misconduct. All of these revelations captured, to many of our amazements, the governor's interest. Because we had become so accustomed to people having a certain view, at least people in power, having a certain view of the issue, and just not being open or willing to reconsider it. And I have to say that part of that, if you want to call it cynicism, that I assumed would pervade, came from discussions that I had had through the years with politicians.
Many people who have worked in the area of the death penalty have, of course, the same view. And I myself, and I know he says this himself, think that it's so important that Governor Ryan's political career was not built upon being a prosecutor himself. So often being a prosecutor is the route to being governor or senator or further political life. And as Governor Ryan himself says, I was a pharmacist.
Sure, no, he's a pharmacist. He talks about that a lot in ways that actually have made a big difference in his approach.
Yeah, he says 50% wrong would put me out of business if I was a pharmacist.
That's exactly right. You know, through the years, through the 90s, I had spoken with many politicians, in fact, some prosecutors as well, who would tell you off the record, you know what, I don't support this death penalty stuff. I think this is crazy. I think it's a ridiculous waste of money. I think it's scary. I don't think we should be in this business. But my constituency is so strongly in favor of it that it would be political suicide for me to vote against it.
And the Republican Party particularly was very pro-death. I mean, for a Republican governor.
It was sort of an equal opportunity kind of thing. I mean, the Democrats hardly have been out there either on the
Right,
issue,
that's
but
true.
certainly, you know, generally speaking, Republicans have been stronger supporters of the death penalty than many Democrats. But what was so inspiring about George Ryan, it was his willingness to read the Tribune series as a human being, not looking at the polls, not putting up a finger and trying to feel where the wind was blowing, but to say, what am I supposed to do given this new information? That yes, a majority of Illinoisans supported the death penalty, but they didn't know all of this stuff that's now been revealed. They didn't know about all these exonerations. They didn't know about the Tribune's findings and the like. And based on that, Governor Ryan decided that at the very least what was necessary was a moratorium. That
And that was very important.
and that was incredibly important.
That was Illinois the first state that imposed the moratorium?
Illinois was the first state in which a governor imposed a moratorium. Now, it's a funny phrase, the governor imposed a moratorium. What the governor really did was simply announce prospectively
Right.
that he would not be signing any death warrants until he got to the bottom of the problem. Had they wanted to, the Attorney General could have still gone to the Illinois Supreme Court and secured death warrants, and the governor basically would have been granting reprieves to those cases, temporary reprieves, until he decided what to do about the cases more generally.
Yeah,
But-
that's a very interesting, actually, technical procedural issue, because of course, some legislatures have introduced statutes imposing a moratorium. That's not what happened in Illinois. As you say, if somebody really wanted to fight it, a state attorney general could have challenged that. So you have the interplay of the different parts of the government in the criminal justice system.
I don't think they could have challenged it so much as they could have put the governor to the task of having to sign individual reprieves in 10 or 15 cases, however many would have been ripe for execution
Exactly.
during the period of the moratorium. But the Attorney General didn't want to do that, in large part, no doubt, because he himself had been involved in a very ugly wrongful conviction case, the Cruz case, that I mentioned earlier, when he was a local state's attorney in DuPage County. But the governor decided he put a moratorium in place and he would create a Blue Ribbon Commission. And the Blue Ribbon Commission would be made up of people who had not been very partisan on the issue. So he didn't call on the strong activists from the prosecutorial community. He didn't call on the strong activists from the defense community. He tried to get people who perhaps had once been prosecutors but were now defense lawyers, people who were prosecutors but had been known as being pretty reasonable prosecutors, albeit ones who supported the death penalty.
Yeah, I think it's a very important point here. He put together a commission which could not be gainsayed. We all know that there are governmental commissions and there are governmental commissions, and so many commissions, there's a news conference when they're appointed. 6 months later, a year later, they come out with their report. Everybody sticks it in their bookcase, and 6 months later in the circular file. It makes absolutely no difference. But actually, this commission, because of the distinction of its members and the quality of its members, in many ways, it resembles the 1929 Illinois Crime Commission, which produced that extraordinary report, which is included on this website here. That 1929 Illinois crime report is a model of scholarship, and if you look at the masthead as to who was on that commission, was exactly the same kind of thing. You could not fault these people. You could not say they were partisan. You could not accuse them of having an agenda. Plus, the commission was appointed in 1926 under a reform mayor, who was subsequently booted out, and it is a credit to both the commission and the subsequent politics that they didn't close down that commission. They couldn't close it down because of who was on it. So in 1929, they come out with their report. That commission, under a different administration, if it hadn't had those blue ribbon people on it, could have been just like the door closed.
To be sure. And in this case, when the commission was appointed, in all honesty, a number of us in the defense community were quite disappointed and quite upset, and believed that it was in fact a commission that was strongly supportive of the death penalty, and that nothing very substantial would come of it. But nonetheless, we decided this is what had been appointed, and we would go with it. We would work with it. And as it proved to be the case, the commission initially, we now know, took a vote, informal vote among its members as to the general question of support for the death penalty. And a majority of the commissioners raised their hands and said they supported the death penalty. And then they began to study it. They began to hear from victims. They began to hear from wrongly convicted defendants. And they began to hear from prosecutors and from lawyers and from judges and from
Experts who studied capital punishment for years.
Exactly. And as they began to immerse themselves in that process, again, resembling what's happened as America has become educated on this issue, they became more and more suspicious of our ability to implement a fair and just scheme of capital punishment, an accurate scheme of capital punishment. So by the end of the day, after 2 years of intense work, when they issued their report, which came up with 85 very significant recommendations for reforming the death penalty system in Illinois.
And that report is really a milestone in the history and study of capital punishment in America.
Well, I think that's clearly right. And it's a large credit to the governor's staff who worked with the commission,
Right.
to Deputy Governor Bettenhausen, who
Absolutely.
threw himself into this with incredible zeal and just wonderful passion. But even with those 85 reforms, a majority of the commission concluded that it would be impossible, even if we did all those reforms, even if we invested so many tens of millions of dollars into these cases, we still would not have a system that eliminated the risk of executing innocent people. And basically, the commission said it's not for us to decide whether that risk is one that's worth enduring, but we want to be clear that risk will in fact be there, and it's up for the people of Illinois to decide whether they want to bear that risk in order to get whatever value comes from the death penalty. Well, the governor got that report, and initially, from many indications, the governor was willing to accept that report and willing to proceed along the lines of reform and recognizing that the reforms needed to be put into place and hoping that the legislature would react.
And indeed, a bill was crafted based upon the report saying we think this or that should be done with regard to ensuring the reliability of confessions and regarding with suspicion the testimony of jailhouse informants, et cetera, et cetera.
There was a bill, and in fact one bill made its way through the Democrat-controlled House, but at that time there was a leader in the Senate who was very obstructionist on all of these issues, and even though he was an old friend of George Ryan's, he made it clear that this wasn't going to go anyplace. And he basically buried it, much to the great frustration of Governor Ryan.
Politics.
At that same time, a number of people in the defense community, led in large part by the Center on Wrongful Convictions and by the MacArthur Justice Center at the University of Chicago, decided that we needed to approach the governor, whose term would be ending in another year or so from then, and we needed to make the governor understand that regardless of what happened with these reforms prospectively, it ought to be unthinkable to execute anyone who was convicted under the system that did not have those reforms in place. No case, none of the 170 people on Illinois' death row had the benefit of the reforms that the governor's commission had deemed so essential. And we tried to persuade the governor that it was impossible to go back 10, 15, or even 5 years and expect us to be able to recreate what could have been created had a truly wonderful and truly adequate investigation been done contemporaneous with the crime. So we prepared, and we being the defense community, prepared an effort to ask the governor to commute the sentences of all of those who were on Illinois' death row.
And by commute, you don't mean letting everybody out in the street. You mean changing the death sentence to a life sentence.
To a sentence of life without possibility of parole in almost all instances, yes. No one was going to go free unless and until they could prove their innocence, which was, of course, the point of not killing them. But we argued that not only were we absolutely sure that there were some innocent people in this group of 170, although we couldn't yet prove that, but in addition, the even more important premise was that if the system had been proven so failure-prone with respect to the easy question of whether someone did or didn't do the crime, how could we possibly trust that system with the much more complex and sophisticated question of whether someone ought to be killed for a crime they did commit? So, I mean, let's go back to Leopold and Loeb for a moment for an example. There was no question, there was no ambiguity about the fact that they committed the crime. But the question of whether they ought to be killed for that crime was this incredibly complex question that got into all kinds of psychological, sociological, penological kinds of inquiries that Darrow so artfully was able to convince the judge about. Well, that is the situation with every death case. You have a first phase that involves guilt or innocence, and that can be the easy one. The second phase, where you have to look at the background of the defendant and fetal alcohol syndrome and history of abuse and psychological failings, and compare that with future dangerousness and heinousness of the crime, that's the really hard part. And we
should this person die for the crime that they committed?
And we said to the governor, how can you trust a system that's been so problematic with that question? How can you assume it's done a good job at deciding that question, even if you know someone's really guilty in an individual case? And based on those appeals, clemency petitions were filed for the people on death row, and we entered into a very difficult phase because, understandably and justifiably, the prosecutors who were defending verdicts they had obtained, they finally went to battle on this issue.
They did, and there were a series of hearings before the
Prisoner
Review Board. Now, some of these cases were 15, 20 years old, right?
Indeed.
And an extraordinary set of hearings took place in which some of the original prosecutors came and testified. The defendants were not present. Often the defense attorney was not doing any more than just asking for a consideration of certain issues. And these hearings took place around the state and received a great deal of publicity.
There was no question. It was a very, very intense set of hearings, and it clearly for a while shifted the momentum very much against what we were asking the governor to do, to the point that the governor himself at one point said that he had pretty much ruled out the idea that he would be commuting everyone's sentence.
So, and we're talking about clemency petitions on behalf of somewhere around 165, 170 people.
That's
so
right.
It was not a trivial number of people.
No, not hardly. It was the largest pursuit of clemency off of death row that had ever occurred in any state in the United States. And we had mounted a campaign where we understood that these hearings were going to be major setbacks, but nonetheless, we were prepared to try to take this 6 to 8 week period after those hearings until the governor needed to decide to try to remind him of what had happened and why this was such a critical issue and why he ought to be commuting these sentences.
Now, let me see. The hearings are finished in mid-November, right?
The hearings are finished in November, and the governor's has to decide by January 13th is the day he's leaving office.
Yes. Now, a very important aspect of this decision of the governor's is that he decides not to run for a second term. So that becomes another very important point in this whole process, because the governor himself has said on several occasions if he had decided to run for a second term, his whole second term re-election process would have been dominated by this debate.
Well, it's interesting. I'm sure that's true, but it's also interesting that although Governor Ryan had a series of issues that he was not popular on here in Illinois, the polls consistently showed, although he had no way of knowing this ahead of time, that the single most popular decision he ever made was the moratorium on executions. It had 80% support in Illinois. Even though a majority supported the death penalty, 80% still said, we can't support the idea of killing people while the system is under study, while it's been exposed as being that broken. And finally, as we began to enter the last stages of this campaign with these 170 cases in our hands, and the lawyers used to get together and we used to talk about, remember how we did this death penalty case and this one, remember how intense that was, remember how scared we were, remember how hard we worked? Well, factor that by 170, because that's how many cases we have in our hands right now. And it was an incredible responsibility. And it was, at some stage, much more of a public relations campaign at that point. We were lobbying the governor, who was a jury of one with 170 verdicts in his hand.
And a number of other people weighed in. There was a committee of judges and former prosecutors. There was a national committee of legal people. Talk a little bit about that.
Well, absolutely. Part of this campaign that we mounted was to go out and try to show a broad spectrum of support for this issue among some unusual suspects. Not just the Amnesty International or the ACLU, but groups that might not otherwise be expected to support what we were asking the governor to do. The climax of all of this was a weekend in December of 2002, where we basically did a restaging of sorts, a second national conference on wrongful convictions and the death penalty. This time we brought in even more people who had been sentenced to death only to be freed. And they were two on a stage, and the focus was all on trying to remind Governor Ryan of the fact that these people would have been killed had miracles not happened, and yet there were many others on death row whose miracles had not yet come. And in a very dramatic ceremony, a letter had been written to the governor, and each of these men who had been on death row and women came and signed the letter to the governor. And the next morning, on Monday morning, we staged a walk from Stateville Correctional Center, where the executions in Illinois had taken place. And the walk, 38 miles or so, was from the penitentiary, from a few hundred yards away from the death chamber, to the State House. And the walkers were all people who had been on death row. We called it Dead Men Walking. And each of them held the letter for a mile or two and then handed it to another man who had been on death row. And it was a relay walk started by Gary Gauger, who had been sentenced to die in that very chair from where he was departing. And the final walker, some 7 or 8 hours later, actually more than that, some 12 hours later, was Anthony Porter, whose case had garnered so much attention. And it was such an amazing day, such a intensely spiritual day, to see these men who had suffered so much for things they didn't do, yet being willing to give so much of themselves to try to help others in their situation. And I remember, even though we had been very strict, everybody's supposed to walk 1 or 2 miles. When we got to within 10 or 12 miles of downtown, people just refused to stop walking. So we finally, by the time we got close to downtown, more people had gathered and more people had gathered. Helicopters were flying ahead. At one point, 6 or 7 of them walked past 26th Street in California, the famous criminal court building, and spontaneously went on the stairs and hugged each other. One of them pulled out a harmonica, and they all sang Amazing Grace, and the stairs of where they had been waiting to be killed for many years after they had had their trials and were through waiting post-conviction proceedings and the like. That night, after this march, if that all hadn't been enough, we presented a special showing of the play The Exonerated, where actors from around the country, well-known actors, Richard Dreyfuss and Danny Glover and Mike Farrell and many others, came in for a special showing for Governor Ryan. And it was an amazing play to watch, because you're watching this play about people who had been on death row and were exonerated, but the 300 people in the standing room only theater were all watching the governor watch the play, because everyone knew that within a week, 2 or 3, he was going to have to make this decision. So when the governor smiled, it was important. When the governor frowned, it was the old Kremlinology of reading tea leaves. And finally,
and the timetable was the governor technically leaves office January 1st. His term is over, but he has until the 18th, 19th?
No, he leaves on January 13th.
January 13th
Actually,
is his last day.
Yeah, January
office.
13th at noon is when he was turning over the office. So he had until then, and he took almost all of that time. Up until a couple of weeks or a week or so before the decision, it was quite clear that he was still very undecided. He was waffling, and I had the privilege of spending a good amount of time with him and being brought into the inner circle and to discuss this with him, as many others had the opportunity to do. And we had no idea. I had no idea. And I don't believe he had any idea what he was going to decide. And then finally, in that last week, he began to get some moral certainty and some moral closure on the issue, and realized that he could live far better with the idea of commuting these sentences, putting these people behind bars for life, leaving open the possibility of them being freed, than he could live with the possibility of denying them relief, watching them be executed by a future governor who might not have been as sympathetic or as educated on these issues as George Ryan had become.
One of the things that was so striking that Governor Ryan said after his decision was he said, every time I shuffled through the cases, they came up differently. Every time I did the sort, I got a different group of cases coming up as some to commute and some not to commute. So tell us, on the fateful day, the exact day was January
11th. On January 10th, the governor decided to pardon completely 4 individuals who had all been victims of torture and for whom there was no other reliable evidence. So those men were released on January 10th. And on January 11th, at Northwestern Law School in Lincoln Hall, the governor came and announced his decision to commute the sentences of the remaining 167 people on death row. And it was a very difficult day in many ways. On the one hand, obviously, it was a great triumph for many of us who had worked so hard on the issue for so long. On the other hand, we were very sensitive to the intense pain that this was causing to victims' families and others who had been affected and who believed, honestly, that the death of these perpetrators, these convicted perpetrators, was essential to their well-being. So we tried to be very sensitive to those competing needs and the real pain that was being experienced. And I know it wasn't always felt that way. And in retrospect, I kind of regret that we didn't, for example, tell the audience that it was inappropriate to be engaging in any applause or anything like that. That we should have probably treated it more like a judicial verdict and less like a political statement or political announcement. But just as in a courtroom, when someone is freed, there are spontaneous eruptions and intense emotion.
Right.
There was that genuine emotion and intensity in that room. People had been working 20 years on that issue, waiting for that day. And ultimately, George Ryan has now become a tremendously important voice around the country, around the world on this issue. And the Illinois experience remains a very, very instructive experience for those who want to understand not the theory of the death penalty, because that might be easy, but the application, the realities, the practicalities, because that's where the devil lies in the details.
Thank you very much.